I said I knew I was lying on that day I went to trial. The jury knew I was lying on that day when I went to trial. And furthermore, Your Honor, you knew I was lying. Welcome to the In and Out Podcast, where I have conversations with dope individuals who share their extraordinary stories of overcoming hardship, pain, and struggle. I'm Girault, and today I'm sharing my dope story about how I got myself out of federal prison. This is part 2. Part 1, I was talking to y'all about basically how I got myself in the box, how I got myself in federal prison and was given a 151-month sentence, 12 years and 7 months. And I started talking about the whole process of how I was learning how to put briefs together and how to find the imperfection in my case. And when I started finding that imperfection in my case, I started putting these briefs together because I needed to get myself back in front of the judge that kind of despised me. And he despised me because, as I was explaining earlier, I got in front of his courtroom and I lied on the oath. And naturally I was doing whatever I had to do or what I thought I had to do to get myself out of prison. So, that's why I was lying. But several years later, I decided and it was determined that the best way for me to get out was to find that flaw and to tell the truth. And so that's what I commenced doing. One of the things that I learned is they say, one of the things that was said, or was that they say in the legal profession is if you can't win on the facts, win on the procedure. And if you can't win on procedure, find someone else to blame. So I found someone to blame, but I went on procedure also. So I blamed my attorney, but I blamed him for good reason. It was because he didn't tell me what I needed to know. He told me a bunch of what I wanted to hear. And a lot of that probably had to do with the fact that I was paying this dude, and maybe he just wanted to get some experience on my neck. But that wasn't acceptable to me. So after I paid an attorney to go to trial, and then I paid an attorney to go to the appeals court, as I was explaining in an earlier episode, I got to work myself because I realized there was nobody that was going to get me out, or nobody that was going to work on my case, nobody that was going to have the focus and the intensity, and that was going to want to get out more than me. So I started getting into it like I never got into anything else in my life. So I learned about a 2255, which is ineffective assistance of counsel. A lot of people tried it, but very few went. I had to prove that my attorney knew that I was going to lie when I got on the stand. He knew that I was going to lie on the oath. Because if an attorney knows that you're going to lie on the oath, it's illegal for him and highly unethical for him to put you in front of the court, on the oath, on the stand, and actively participate in the subordination of perjury. That's what that's called. When an attorney puts his client or anyone on the stand and participates in asking him questions that he knows are going to be a lie. My attorney did that. It's called subordination of perjury. And I knew I needed to prove that. But the trick and the key was, how in the world was I going to prove this? Because an attorney at this point is now what happens when you're fighting for your life, you're fighting for your freedom, you're fighting to get back to your family. And when you're in any type of court, when you're in federal court or state court, I happen to be in federal court. When you're going on a 2255, which is ineffective assistance of counsel, you have to prove to the judge. There is no more jury. You have to prove to the judge that sentenced you, the judge that presided over your case when you was convicted. You have to prove that a constitutional violation had taken place. You have to prove that the attorney's service to you or the attorney's performance to you fell beneath the average norms that a professional attorney, the standards that have been set for an attorney's professional behavior. And it's very hard to do this because he's not your attorney anymore. At that point, the government will go and basically flip your attorney, and there's not too much flipping that has to be done because the attorney doesn't want to have that on his record of being found ineffective assistance to counsel. So now the attorney essentially becomes an adversary, and he becomes a witness for the government. So obviously I didn't have him on tape. I didn't have anything written that he was going to actually fall on his sword, which in my opinion he should have did. He should have done, because now I'm facing 12 and a half years. I have 12 and a half year sentence when I shouldn't have gotten anything close to that. And it was because this dude gave me bad advice. And so I wasn't able to rely on him to make an intelligent and informed decision when it was in the plea bargaining phase, which is called a pre-trial stage of any trial. So in order to be able to make an informed and intelligent decision, you have to be informed. Well, I'm not well trained in the law. So my attorney was basically feeding me a bunch of bull jive, telling me that I had a weak case, the government didn't have strong evidence against me because they never found any drugs. Lie and tell. Almost every inmate in federal prison, a lot of inmates over federal prison, probably more than 50% of them was convicted of some type of conspiracy, which means they didn't have any drugs in their case. That's why the government created this charge. It's called ghost dope. So that's what I had in my case. So I had to figure out a way to put this dude in a trick box and to get myself out of the box that they had me in. In order to do that, I had to show that my attorney knew or should have known. That was one of the things that I found when I was doing my shepherdizing and when I was doing my law research. I was able to find that an attorney committed subordination to perjury if he knew or should have known that the crime that he was going to put forth on the stand under oath was going to lie. That's subordination to perjury. And that was the trick, because I was able to write the briefs in such a way that I was able to show that you either knew or you should have known. So the knowing part means that he actively participated in subordination to perjury. I needed to prove that to the judge, but I knew that it was going to be hard to prove it to the judge. But the he should have known part goes directly to his lack of performance and his falling below the professional norms of an attorney. And I was able to show that because I was able to show that any reasonable other attorney, based on the evidence and the strength of the case that the government had against me, no normal attorney would have suggested or recommended or advised me to go to trial under those circumstances. So he must have been either crazy, dumb, stupid, or he was a liar. And I told that to the judge when I got back into court. I said, I knew I was lying on that day I went to trial. The jury knew I was lying on that day when I went to trial. And furthermore, Your Honor, you knew I was lying under oath in your courtroom when I went to trial. And that honesty wound up being the keys that helped me walk out of federal prison. Because when I got back in front of the same judge that sentenced me, I reminded the judge that 6 years and 4 months, 2 days earlier, he told me that he thought the case against me was overwhelming. He said he knew I was lying. He said the government knew I was lying. And he said that, in his opinion, I should have taken a plea because he knew I was guilty, and I should have pled out. So at that time, based on the briefs that I already written, once I was back into the judge's courtroom, the same judge that sentenced me, he had already read the briefs, and I was able to remind him, Your Honor, you knew I was lying, the jury knew I was lying, I knew I was lying, and worst of all, this guy, my attorney, Dale Galipo, he knew I was lying, and he encouraged me to lie on the oath. And that was the key to me getting out of prison. Because when you go back on a 2255, it's the evidentiary hearing. And the evidentiary hearing is essentially a credibility determination. So when you go back in front of that judge, the same judge that was the presiding judge over the trial when I went to trial, that same judge, if he believes I'm telling the truth, I'm going home. If he believes I'm lying, I'm staying in prison. And that's all it is. It was a credibility determination. And he knew I was telling the truth. And I told him, I said, Your Honor, I was raised as a Christian. And one of the things that my mother used to always tell me, and I know it's in the Bible, is the truth will set you free. And I said, Your Honor, when I came back in front of you, I knew that I could essentially get more time, that I could literally be charged again for coming and knowingly conjuring up this story when I was at trial. But one of the things that I said is, I'm going to tell the truth, I don't care what happens. And on this instance, I'm telling the truth, but on that instance, I was lying. And Your Honor, I believe you know that. And that's when he overturned all my convictions and I got immediate release and walked out of federal prison. I'm Girault, and this is In and Out Conversations.